Dear colleagues, it's a great honor and privilege for me as the president of the European Law Institute to be opening this event, the second Ole Lando Memorial Lecture. Ole Lando sadly passed away on the 5th of April 2019. The sad news quickly spread all over Europe, and his death triggered an unprecedented avalanche of very emotional emails. It was one of those arrangements where a few hundred people click reply all to a few hundred people, with colleagues from across the globe sharing their good memories of Ole and expressing their grief as he was no longer with us. After a period of joint mourning, the discussion quickly turned on how to keep the memory of Ole alive. And it was decided in the end that there would be an annual Ole Lando Memorial Lecture, which could be hosted by the ELI every second year, which is a great privilege, which in the other years, another organization would be hosting the lecture. And it was only natural that the first Ole Lando Memorial Lecture, which took place in October 2019, was hosted by the Copenhagen Business School, where Ole had spent so many years of his life. It was held by Hugh Beale, who, as everybody immediately agreed, was the most obvious speaker for that purpose. And at the first lecture, decisions were also taken to establish certain traditions. And among these traditions is the tradition that each speaker nominates the speaker of the next year. So Hugh Beale nominated Christian von Bahr, again, the most obvious speaker. And Hugh will introduce Christian, and towards the end of the evening, Christian will then announce whom he has nominated for 2021. But before I pass the floor to Hugh, let us hear what a number of very close colleagues of Ole have to say about him.
Sometime early in 1995, I got hold of a copy of the Principles of European Contract Law, Part 1. I was so impressed that I decided to write and publish a review essay in one of the leading German law journals. A little later, I had an opportunity for a comprehensive exchange of views with the man who had initiated and guided that project with Ole Lando. That was when we traveled together in my car to a conference in the Czech Republic. We talked, inter alia, about the possibility of extending the work of the Lando Commission into areas hitherto largely unexplored, such as set-off, prescription, plurality of debtors or of creditors. These plans eventually materialized in the form of the Lando III Commission. For me, that was the beginning of a period of intensive and fruitful cooperation with Ole and with a stellar cast of colleagues assembled by Ole for that purpose. I'm delighted that the European Law Institute has decided to organize and sponsor an annual Ole Lando Memorial Lecture.
Dear friends, for me, Ole Lando was a very special person. Not only did he invite me to join the outstanding group of lawyers in the Lando Commission, he always, despite being a very busy person, always found time to join us in various occasions to which we invited him. He was very popular among our students and among our doctorants, not only because of his broad knowledge, but also because of his personality and humor.
I remember very well that Ole always knew whether what my colleagues and I were doing was, in his view, right or wrong. And he never hesitated to let that know. He always reminded us to work in the area of contract law and beyond, truly European, always to think in also building European law, be it by developing principles, be it by doctrine, perhaps less by legislation. He was not the only one, but one of the first really European lawyers I met, and I miss him.
I had the privilege of working with Ole on his principles of European contract law. The Commission started its work in 1980, and it went to proceed and it finished its work in the early 20th century. The members of the drafting group, which was perhaps the most important part of the Commission, were Hugh Beale from Warwick, Ulrich Drobny from the Max Planck Institute, Roy Good from Oxford, myself from Utrecht, Ole from Copenhagen, and Denis Talon from the University of Paris. And of course there was the secretary Matthias Sturmer. It was not unimportant that Denis Talon took part in the Commission because French at the time was at least on a par with English. And when Denis would say, "Cela ne se dit pas en français," that would be the end of it. We would no longer accept it. Now there is something I must tell you about the procedure of the Commission. How was it possible that somebody who at the time when we started to work was already in his 70s could muster the strength to do this work? Well, the secret of Ole was to have his presidential nap. It was a sleep of maybe 20 minutes, and that would give him full refreshment and possibility to proceed with the work.
Ole Lando had an acute mind, a sound judgment, and great knowledge. In fact, he was profoundly human, and he greatly enjoyed discussing with young scholars. We all were very much inspired by him. I had the fortune to meet him at the study group on the European Civil Code, at Unidroit, and also a couple of times in Paris. He came while we were working on the French contract law reform, and he had a great admiration for the French Civil Code, less for the attachment of the French scholars to that tradition. Because indeed, Ole Lando was a pioneer. We all know that he founded the Commission on European Contract Law, which gave birth to the PECL. What is less known is that in 2010, he decided to write the new PECL. And he gathered a small group of friends, and I was fortunate to be in that group. And we held 2 meetings, but then we decided not to go further because the European Commission had decided to take up that subject. Now in 2020, I regret that we didn't accomplish that task. But I was full of admiration for the energy that Lando put into this new project.
Ole Lando has been a great inspirator of European private law. He has founded and chaired the Commission on European Contract Law in a kind and charming, but also a very effective manner. Hard-working, but also life-loving. He also liked to hear diverging arguments and opinions of, as he said, Männer anderer Meinung. He was open and welcoming, also to young academics, as at that time, myself, the secretary to the first Commission on European Contract Law. And Ole was at the same time integrationist, but also very conscious of the linguistic and cultural diversity among the European nations. Mange tak, Ole. Vielen Dank. Merci.
Ole was a remarkable man. He was very learned. He was very modest. He was extremely kind and pleasant to work with and to chat with privately. And he was tenacious in pursuing the goals that he had set for himself. One of his particular concerns, his admonishments to the group that he repeated often, was that we should always strive for clarity and simplicity in the draftings, in order for the principles to be easily accessible to all readers, both the private person and, as he used to say, the ordinary businessman. And I think it was a very wise lesson to all of us.
I miss Ole Lando. I miss his kindness and I miss his joy. By his wonderful personality, he always made sure that discussions were open-minded and that people were tolerant towards each other.
Dear colleague and friend, and by saying what a privilege and a pleasure it is to introduce this evening's lecturer, Professor Christian von Bahr, who's director of the European Legal Studies Institute at the University of Osnabrück. Professor von Bahr founded an Institute for Private International Law and Comparative Law at Osnabrück back in 1987. By 1991, he'd published prize-winning work on private international law. But at the same time, he was working in the field for which he's perhaps best known, his comparative work on European private law, beginning with a 2-volume work on the Common European Law of Torts, a fascinating study, which I'm glad to say is published in English as well as in German. But meanwhile, Christian had joined the second Lando Commission. A little bit disingenuously, he always claimed that he knew nothing about contract law. In reality, of course, he was an invaluable member of the group. And I have to assume that he enjoyed the experience, because in 1999, he set up a project that employed broadly the same method that Lando had used, a restatement based on a synthesis of the various national laws, but on a much broader basis, the aptly named Study Group on a European Civil Code. The work of the many teams that was submitted to the coordinating committee ranged across almost all topics of the law of obligations and ultimately went into the law of movable property and even the law of trusts. The deftness with which von Bahr organized the project and raised the money to pay for it were a source of wonder to me. And as you will know, the principles produced by the study group, combined with the Lando principles and the work of the ACI group, fed directly into the draft common frame of reference, which was produced by the Network of Excellence that was chaired by von Bahr. Now, this work was not just an intellectual achievement. To most of the participants, and I think those who spoke in that memorial video are testifying to this, it was important in personal terms. Everyone who knew Ole Lando will remember his personal warmth, and the meetings of the Commission on Contract Law were conducted in a like spirit. Not only did we enjoy the sessions, but many of us developed deep and long-lasting friendships with our colleagues from all over Europe. But it's very much to von Bahr's credit that he was able to create a similarly warm atmosphere at the meetings of the study group, which included many more colleagues and particularly many young researchers, all of whom were welcomed to the group and their views listened to. The result was the formation of something like a family that perhaps found it easier to get along for a few days a year than they would have done if they'd been together the whole time. But many of us, I think, and I remember Christina Ramberg saying this, we actually spent more time with our European study group family than we did with our real family. And in time, that family was extended to stakeholders and others who attended the many meetings around the drafting of the DCFR and later the Common European Sales Law. And I mention this not just because I think it was a remarkable achievement in itself, but because in large part it was a desire to keep these connections and opportunities for exchanging ideas going that led to the foundation of the ELI. And this makes it particularly gratifying that the ELI has made von Bahr's lecture this evening possible and, as the President has mentioned, has offered to host the Ole Lando Memorial Lectures as part of every other year's annual conference. Now, Von Baar's achievements that I've mentioned so far might have been enough for most people, but not for von Baar. He established the European Legal Studies Institute at Osnabrück in 2003, and he set about a new project on common European property law, the second volume of which was published last year. And he's now started a new project on the common European law of the natural person. He has far too many other publications and distinctions for me to mention in the time available. What do you say about someone who has hundreds of publications, in addition to winning the Leibniz Prize as a corresponding fellow of both the Académie de droit comparé and the British Academy, an honorary master of the bench at Gray's Inn in London, and by my count, and I'm probably out of date, has at least 8 honorary degrees. Christian will correct me, I'm sure. What I will say is that I can think of no one better qualified to give the Ole Lando Memorial Lecture. Just as we think of Ole as the father of the notion of European contract law, so if anything like a European civil code is ever adopted, I think paternity suits will be brought against von Baar. He's definitely responsible for the draft common frame of reference, jointly and severally with some others perhaps, but at the very least he was primus inter pares. And I understand that his lecture tonight will draw on some of his new work, and afterwards we should have a chance to discuss. You've noticed on the timetable that if you're being asked that if you have questions or comments, you put them into the Q&A box, and after the lecture I will try to feed them, summarize them and feed them to the lecturer. So I'm delighted to invite Professor von Baar to speak to us on contract law and human dignity. Christian.
Thank you very much. And first, good afternoon to everybody. And thanks to you, Hugh, for that kind introduction. Let me start by saying that Ole Lando was interested in the law governing commercial contracts. This second lecture held in his memory will, as I promised to Ole's sons, also be about contract law, but it will not be about commercial contracts. Rather, I have decided to direct my and hopefully your attention to those aspects of contract law which are directly affected by fundamental and human rights law. At first sight, one might think that the one and the other only rarely get into conflict. Agreements are normally seen as something good. How can they clash with human rights? But I hope to be able to show that on closer analysis, there is a lot to be said about agreements which for mainly or at least predominantly constitutional reasons cannot be held up as binding contracts. My subject is closely connected with the law governing the natural person or physical person. Such a person is a human being who, within the framework of private law, deals with other human beings and so-called legal persons. It is about the public face of the human being. Persona was the mask of an actor by which one could recognize the character he played and which helped to better understand his voice. A human being appears as a person when he or she comes into contact with other subjects of private law and puts on his or her character mask for this purpose. The law of the natural person is therefore not concerned with the philosophical question of what a human being is, but with his relative relationship to others, and thus also to a large extent with the framework within which he or she can conclude contracts with them. A person is a person because he or she has access to the forms of private law. What does that presuppose? I think we are dealing with 5 components. A person must be 1, a bearer of rights and obligations. Without this basic requirement, he or she could not enter into contact with someone else in a way which is relevant under private law. Therefore, correctly formulated, a human being is not a person, he or she has a person. In any case, under Article 6 of the Universal Declaration of Human Rights, and I quote, "Everyone has the right to recognition everywhere as a person before the law," end of quote. Human existence also has both a physical and a mental and spiritual side. For this reason, the legal system, my second point, must remove the body and dignity of the human being from internal private law transactions or from the trade. Disposals of the body, soul, substrate of the person must be prohibited, indeed impossible. 4. If a human being were able to objectify himself or herself, or in cooperation with others, he or she would be deprived of his or her role as a person, and thus of his or her authority to participate in legal life. Each individual has 3, a sex. If, on the other hand, he or she is regarded relative to other people as a person, he or she is attributed a gender for individual purposes. Which purposes these are or may be, how many genders the legal system permits, who is allowed to change from which gender to which other gender, in which way, and what consequences are associated with this, are consequently also questions of the law of the natural person. Part of the person, 4, is his or her name. If a person had no name at all, whole areas of law would remain closed to him or her. All register-bound rights, for example, are necessarily name-bound rights. Finally, and 5, it belongs to the person that he or she, age and mental capacity reserved, is allowed to arrange his or her private legal life autonomously. He or she has, as we say, capacity to contract. The human body is legally thought of as a whole. A human cannot split his or her body by contract, dispose of it or its parts like an owner, sell it or give it away. Closely connected with the human body is his or her dignity. The insistence on the dignity of the human being also sets limits to his or her private autonomy. Dignity always comes into view when people set about making themselves or others into objects. Today, the sports media like to talk and write that the football club Y bought the player A, and that this player currently has a value of X million. Although a shorthand formula for an arrangement surrounding the conclusion of a labor contract, talking of a sale disrespects human dignity. It is similar with the bride money agreement, under which the bride's parents let the groom or his parents promise them money for the marriage of their daughter. In court would mean degrading the bride to a kind of commodity, irrespective of whether a bride price is still the custom in some non-European societies and irrespective of our own history. Further illustrative material is provided by the question of whether a woman can effectively contractually commit herself to her partner to use contraceptives regularly, and whether an employer can insist on a clause in the employment contract under which the employment relationship is made subject to the resolutive condition of the employee's marriage. The German courts have denied both. In my view, the result follows directly from the consideration that contract law must not allow room for agreements that violate the Constitution. Quite rightly, the French Conseil d'État banned a spectacle announced as dwarf throwing on the grounds that, and I quote, une telle attraction porte atteinte à la dignité de la personne humaine. A country without a written constitution will most probably have more difficulties in arguing such a case. Statutory contract law no longer distinguishes between men and women. The question of whether a person is a man or a woman, or a member of another, and then which sex, therefore arises in a contractual context only at the level of some individual arrangements. For instance, when a public bath is at a given time open to women only. The question of whether a person is a man or a woman does, however, still play a significant role in some other areas of law. Exempla gratia in family law, criminal law, labor law, and company law. At least the times when a woman, married or unmarried, was deprived of the right to dispose of her own property or to acquire property independently are over. Where other law sectors are still based on gender, the corresponding rules are subject to a constantly increasing pressure to justify their application. In the long term, the fundamental question is whether the legal distinction between man and woman, or father and mother, should and can be maintained at all. For our purposes, it is equally important that in present-day Europe, you cannot change your gender anywhere exclusively on a private basis. This always requires some form of state involvement. Nor can one acquire gender by contract, neither permanently nor for a limited period of time. For some sportsmen and women born with characteristics of both sexes, this would be the solution to their problem. However, all private law entities are still not open to all natural persons without restrictions. On the contrary, the legal system makes it more difficult to some groups of persons to have access to certain private law options, or even denies access. This also comes under increasing human rights pressure. I dare to remind you that under Section 1(6) of the English Law of Property Act 1925, and I quote, "A legal estate is not capable of being held by an infant," end of quote. This is, in my view, hardly compatible with the UN Convention on the Rights of the Child. Despite the mitigations of this strict rule under trust law, and despite the possible argument that this is only another way of distinguishing between active and passive capacity, i.e., the child has the rights, the trustee exercises them on the child's behalf. It remains the case that the child has no rights at law at all. On the other hand, however, it is conceivable that property law grants persons with physical disabilities more, not less, more rights against their fellow citizens than persons who do not suffer from such particularities. This can be observed, for example, in Italian case law on rights of way over private property for people with walking disabilities. The private law of the natural person establishes, secures, and forms the participation of the individual in the private legal system. Legal subjectivity or personality is the prerequisite for active legal capacity. Active legal capacity is an expression of legal subjectivity. Physical integrity and dignity underpin and require passive and active legal capacity. Assignment to one gender opens and closes, at least at present, access to individual institutions of private law. And finally, the human being not only has a name in order to be able to assign rights to him or her, but also so that he or she does not have to identify him or her with signs, numbers, or even like goods with barcodes alone. Certainly, many persons share the like name, but that is not, at least not under the continental systems, the same name. In the private law of the natural person, we are dealing with rules that elude private autonomy. No one, not even a healthy adult, can decide on the characteristics that the legal system attributes to him or her for the sake of his or her personhood. Paragraph 19(2) of the new Czech Civil Code spells out that, and I quote, natural rights connected with the personality of a person cannot be alienated or waived. In France, the principle of indisponibilité de l'état des personnes applies. Consequently, it is always a matter of distinguishing between transactions that can still be organized in the forms of private law and those for which private law no longer offers or is no longer allowed to offer a framework. The law of the natural person prevents people from putting themselves or others above themselves. Human dignity implies limits to the power of disposition over oneself. In the European legal system, there is repeatedly talk of human beings having inalienable, unavailable, unsaleable, or non-transferable rights. This is, in my view, not very satisfactory. The way of speaking of conveyancing, etc., refers to individual rights of patrimony. But that is not what this is about. Man does not acquire his personhood, not even by birth. It is attributed to him by the legal system from birth. In essence, the private legal system removes from its mechanisms of action all characteristics which, in its view, constitute man as a person. In other words, no human being can release himself from his own person, split it up, or leave it to someone else, neither by unilateral declaration nor by contract. In a constitutional perspective, this seems self-evident. In a purely private law perspective, this point is much more difficult to make. It is in the nature of things that the private law of the natural person is shaped by human and fundamental rights. After all, both fields of law are concerned with related subjects. Again, however, terminology becomes a problem. I understand human rights to mean subjective rights which have their source in an international treaty, and fundamental rights to mean rights which have their source in the Charter of Fundamental Rights of the European Union or in a written state constitution. And I count both of them in terms of substance among the objects of constitutional law. In principle, human rights apply to everybody. Fundamental rights may have a narrower personal or territorial scope. A question independent of this is that of the status of such constitutional law in terms of legal hierarchy. The fundamental freedoms, by the way, are also ambiguous. The European Convention on Human Rights defines them as human rights and fundamental freedoms. In a context of European Union law, on the other hand, fundamental freedoms stand for the internal market related freedoms of EU citizens. The latter create, among other things, a comprehensive right to mobility, which must not be violated even by rules of personal law. Exempla gratia on the naming of children, on the recognition of same-sex marriages concluded within the EU and the marriage of minors. I do not have the time to address even the most important human and fundamental rights sources here. In addition to the Universal Declaration of Human Rights, with its prohibitions of slavery and racial discrimination, I would particularly mention Article 15.2 of the UN Convention on the elimination of all forms of discrimination against women, which reads, and I quote again, "States parties shall accord to women in civil matters a legal capacity identical to that of men and the same opportunities to exercise that capacity. In particular, they shall give women equal rights to conclude contracts and to administer property, and shall treat them equally in all stages of procedure in courts or tribunals." And the same article is in its section 3 even more specific. I quote again, "States parties agree that all contracts and all other private instruments of any kind with a legal effect, which is directed at restricting the legal capacity of women, shall be deemed null and void." Article 16 of this convention also obliges the states to grant wives the same rights to choose a family name as men. Under Article 7 of the UN Convention on the Rights of the Child of 1989, every child must be entered in a register immediately after birth. It has the right from birth to a name. Article 12, para 2 of the UN Convention on the Rights of Persons with Disabilities recognizes, I quote again, that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life. To implement this principle, Article 12, para 3 of the Convention states that state parties shall take appropriate measures to provide access by persons with disabilities to the support they may require in exercising their legal capacity, end of quote. This is a clear rejection of the law of incapacitation, which we have in various European countries up to the present day. Of course, the European Convention for the Protection of Human Rights and Fundamental Freedoms and its additional protocols is particularly relevant for us Europeans. Its most important warranties from the point of view of private law are found in Article 8, that is the right to respect for private and family law, and in Article 14, which states that the enjoyment of the rights and freedoms set forth in this convention shall be secured without discrimination on any ground, such as sex, ... Increasingly important is Article 21 of the European Convention for the Protection of Human Rights and Dignity of the human being with regard to the application of biology and medicine, which states I quote again, that the human body and parts thereof shall not be used as such for financial gain, end of quote. There is a lot to be said about this rule. Hardly anything else today is as well protected in terms of fundamental and human rights as the passive legal capacity of the natural person. Whoever enjoys legal capacity is a person, and therefore belongs neither to himself nor to others. Man is a natural person simply because he is a human being. This is an axiom that is not open to any further justification. It is accompanied by a constitutionally protected right to legal capacity. It is closely linked with the constitutional protection of the right to life of man. Man has legal capacity as long as he lives. Who is not yet or no longer alive does not have legal capacity. Human life is the factual side of legal capacity. Legal capacity is the legal side of existence as a human being. A distinction is usually made between passive legal capacity, the capacité de jouissance, or Rechtsfähigkeit in my own language, and active legal capacity, the capacité d'exercice, or Geschäftsfähigkeit. Passive legal capacity then means the abstract ability to be the bearer of rights and obligations. Active legal capacity means the concrete ability to acquire and dispose of rights through one's own legal action, and also to bind oneself of one's own will by assuming obligations. However, the continental distinction between passive legal capacity and active legal capacity, and I think this lesson is taught by English law, is not without its problems. It wants to be executed under constitutional control. The right of man to be recognized by the legal system as a bearer of rights and duties has its ultimate reason in the protection of his dignity. This means that every human being must be endowed with the ability to substantially participate in legal life. For this reason, as I have already noted, and I know I'm in dangerous waters, it is problematic in human rights terms to deprive minors of ownership in land. And ultimately, for the same reason, incapacitation is no longer tenable in human rights terms. We should never forget that the separation between ownership and the power to exercise rights is a popular trick of all totalitarian states. If one wants to reduce the distinction between contract and tort law to a simple denominator, one could perhaps say that a contract is something fundamentally good, a tort something fundamentally bad. Tortious acts violate the rights of others. Contracts are based on the agreement of the parties. There are, of course, limits to the legal relevance of such agreements. In the field of contract law, this is often expressed in the sense that contracts that are contrary to law or morality are null and void, or at least unenforceable. This internal perspective of contract law, of course, dates from a time when fundamental and human rights did not yet play any role, or at best a political and programmatic role. Today, I think things are fundamentally different, at least in continental Europe. Constitutional law, not contract law, deserves precedence. It is therefore essentially irrelevant how contract law reacts to violations of fundamental and human rights on its own initiative, including whether it ranks the relevant constitutional articles among the laws or the morality that trigger the private law sanction of nullity. It is solely a matter of determining the scope of action that constitutional law assigns to contract law under private law. This applies in particular to the right of violation of dignity. As far as conduct that violates dignity is systematically a matter of tort law, the latter, i.e. tort law, has in some places already become a piece of genuine constitutional private law. Contract law should, I think, follow this. Human rights is such a fundamental category that it is not dependent on auxiliary arguments, such as the content that inhuman contracts are immoral, even if one of the parties has agreed to their own degradation. It is precisely in such cases that one is not at all dealing with an event under internal contract law, but with a purely factual event that takes place outside the legally possible organization of life. Not because it is immoral or unlawful, but because constitutional law closes off the parties' access to the body of rules of contract law. When it comes to violations of human dignity, there is no way to distinguish any longer between vertical and horizontal effects of constitutional and human rights. Of course, violations of dignity that have been realized by mutual agreement occur much less frequently than those which are caused by others. Two basic forms can, I think, be distinguished. In the one group, one has to deal simultaneously with interventions in the body, in the other with degradations which leave the physical condition of the person affected untouched. We have already given examples from the second group. Directly with reference to Article 1 of the German Constitution, and without the detour via paragraph 138 of the German Civil Code, that is the one on immoral contracts, the Düsseldorf Labor Court of Appeal also rightly considered the so-called, wonderful expression, the so-called ethics guidelines of an American department store chain to be ineffective, which wanted to prohibit private love relations between its employees if they affected the working conditions, as they said. However, the focus of the more recent discussion on the significance of constitutional law for private autonomy has shifted to agreements which deal either with euthanasia or other contracts affecting the bodily functions of the human being: surrogate motherhood, organ and tissue trade, operative sex change. For reasons of time, I shall confine myself here to a few concluding remarks on assisted dying. Assisted dying is a very sensitive issue. It is best understood as a separate case group, which is closer to killing others than to suicide, but is nevertheless characterized by the peculiarity that it is about people who want to live life in a self-determined way, but who cannot any longer realize this wish through their own behavior. They are dependent on external help. The state has a duty to protect both the dignity and the life of the people living in its sphere of influence. Consequently, both dignity and life are not only deprived of state, but also of private arbitrariness. No one may raise himself to the lord of life and death of another, not even with his consent or as his representative. Nor does it matter whether it is about a healthy adult or a sick newborn child. Assisted dying covers a wide range of circumstances. 1. The form of indirect euthanasia is comparatively unproblematic, which is a mere pain treatment or palliative care designed to make it easier for a dying person to twilight, and is therefore also permitted if it is accompanied by a shortening of life as an unintended but unavoidable side effect. 2. Euthanasia in the form of assisted suicide occurs when a doctor or a person close to the suicide victim remains at the side of the person concerned until the last act necessary for the suicide, but does not intervene and respect the person's wish not to be resuscitated. The suffering person hastens their own death, and the medical worker does not intervene. This, according to the correct view, is also not a crime, because it strengthens the patient's right of self-determination, which is characteristic of his dignity. The doctor does not violate his contractual obligations. He fulfills them because they have changed in content. Euthanasia in the form of discontinuation of treatment is often inaccurately called passive euthanasia. A termination of treatment is in principle possible at any time at the patient's request. Nobody who can make a legally binding statement may be treated against his will. The most difficult and at the same time most controversial situation is 4, the one in which a patient who has become incapable of forming his or her own will can no longer be treated medically. He or she can only be cared for, but suffers incurably from unbearable conditions and has expressed his or her will to die in free self-determination, but is no longer able to put it into practice. The last step must be taken by a doctor who has previously consulted carefully with other doctors and close relatives. One then has to deal with a special case of killing on demand. It is not a case of a treatment interruption, but a care interruption. Although it is carried out by active killing, it serves to end a severe suffering in compliance with procedural and diligence standards. In contrast to the basic form on killing on demand, it is an act of medical care. The patient does not use his situation to make others the instrument of his death wish. He is no longer able to do so, even if he or she hoped to do so while still in a healthy state. The wish to die that was previously expressed is now only an indicator that the suffering has become truly unbearable. Such a situation, and that is important to me, cannot be decided by reducing it to a dispute about the existence or absence of a right to die. The law of assisted dying should primarily be geared to the plight of the person concerned. He or she is at the center. However, there are absolute limits that are apparent in the everywhere punishable killing on demand, if it occurs outside the medical care of seriously ill patients. But the situation in which such a person finds himself cannot be compared with the situation in which a man weary of life draws others into his own misery because of his desire to die. The manner of speaking of the right to live or to die only causes an unnecessary hardening of the law in an extreme situation of human existence, in which the person concerned is dependent on care. There is neither a creditor nor a debtor of an alleged subjective private right to die. But this does not change the fact that, depending on the context, self-determined passing away has implications for the subjective public rights of those who want to respect the self-determination of the patient. One of the laws that has been, in my view, particularly successful in achieving this balancing act in the spirit of the Oviedo Convention is the Belgian law of 2002 on euthanasia. The law defines euthanasia as, and I quote, an act carried out by a third person by which the life of a person is deliberately ended at the request of that person. And adds in another article that a doctor who provides euthanasia, quote again, does not commit a criminal offense if he is satisfied that the patient is of age or emancipated and at the time of the request is capable of acting and is aware that the request was made voluntarily, deliberately, and repeatedly, and was not made under pressure from outside, that the patient is in a medically hopeless situation and invokes persistent, unbearable physical or mental agony that cannot be alleviated and is the consequence of a serious and incurable accident or illness, and observes the conditions and procedures prescribed by the present law. That was a long quote. The physician must consult an independent colleague, give the patient comprehensive advice, and come to the conclusion that there is no other reasonable solution. The patient must have the opportunity to discuss his request with the person he wants to meet. Special precautions apply in the event that the death is clearly not likely to occur in the foreseeable future. The will of the person must be recorded in writing and can, of course, be revoked at any time. A similar regime applies, by the way, in the Netherlands. Now, as said, I could have exemplified my subject by other questions. I'm thinking, for example, of surrogate motherhood or the countless constitutional implications that characterize the modern right to belong to one sex. But I had to leave it at one example. What was and is important to me was to show that modern contract law must be oriented to a much greater extent than is usually perceived today towards the constitutional law that is superior to it, and in turn towards the concept of human dignity. Contract law exists only within the framework and assigned to it by constitutional law. Everything that takes place outside this framework is not the subject of an obligation relevant to contract law. It is necessary to define this framework more consciously than it seems to be the case so far. Perhaps we also need to reconsider the traditional attitude of academics working in private law to regard their field as the supreme discipline of law. I thank you very much for your time and for listening.
Christian, thank you and congratulations on a really interesting lecture. It's presented us with some really challenging ideas, and I'm sure there are going to be many questions and comments. So perhaps I can invite the audience to put their questions or their comments into the Q&A box, and I will pass them on as best I can. Whilst people are typing, maybe I can ask a question of my own. which concerns me as coming from a country which has no written constitution. To what extent are the various fundamental rights that you referred to merely the creation of conventions or constitutions, or to what extent do you regard them as flowing from some sort of natural law, so that they should be recognized, must be recognized in every country that treats itself as regards itself as at all civilized?
My own perspective is rather the latter. There should be human rights which are applicable in every civilized nation. But technically, of course, there is the distinction between human rights and fundamental rights, as I call them, the latter being part of the list of fundamental rights in a written constitution, and the others being part of an international treaty. But I don't think it matters so much whether you have a written or a non-written constitution. What matters is that you accept these rights as being part of your constitutional law.
Okay, thank you. So let me pass on the first question from Hans Schulte-Milke. Christian, do you see any need for European harmonization regarding the law of the natural person beyond the Oviedo Convention? Would there be a legal base in EU law? And do you detect cultural differences which should be respected?
Thinking about an area of European private law does not necessarily imply that I want to harmonize everything. I'm not, to be honest, far enough to be able to answer that question. I need more research. But when it comes, for instance, to the rules governing the conclusion of contracts by people with a capacity problem, I think a lot could be done in that respect. The Lando principles have nothing on that. The DCFR has nothing on that. And whether there is a legal basis in EU law, the answer is probably no, but I must check that again.
Thank you. Okay, now a question from Christian Twig-Flesner. Christian von Bahr, you said earlier on that contract law is gender neutral, and Christian Twig-Flesner asked whether that's really the case. Presumably, gender neutral requires more than just avoiding a gender-specific bias, which should also ensure that the rules don't inherently favor a particular gender. On that basis, does contract law need a thorough review to ensure that it's fully in compliance with fundamental rights?
That is a very difficult question, and I'm not sure whether I'm able to answer it. On the level of drafting of our contract law statutory provisions, I see no discrimination at all. Whether there are rules that favor men or favor women, to be honest, I cannot say. I suspect there are such rules, but I have not tested the whole of contract law. A while ago, I have tried to answer the question whether a test like negligence has some gender-specific implications. So that one could argue that the negligence test developed in the perspective of the male 50% of the population. But I couldn't find any proof for that thesis. So for the time being, my answer is no, but I leave that under the reservation that I simply have to look into more detail.
Okay. And now we have I think, a really rather fundamental question from Raja Chatila. Is the concept of dignity peculiar to Western philosophy? If not, how is it expressed in other civilizations?
That one is difficult.
Yeah.
In my understanding, the concept of dignity is universal. At least it should be universal. In real political life, it is obviously not a universal principle because it is disregarded every day, everywhere. But I cannot see why that should be a part of Western philosophy. Why should that be different in Japan, in Korea, in China, in Taiwan? I have no clue. My answer is that should be a universal approach.
Mm-hmm. So it must be a question of identifying the equivalent concepts in other systems, I guess.
Yeah, maybe
terminology, if you like.
Maybe religious concepts still play a role here, mm-hmm. because human dignity in itself has a root in religious ideas.
Mm-hmm. Okay, so now Hector McQueen asks, to what extent have human rights evolved from their earlier recognition within private law, especially the private law of persons? You seem to show a high congruence between the rights, albeit the human rights / fundamental freedoms have developed in a new political era during the 20th century.
Thank you for that question, Hector. It is true that when you look into the old codifications in continental Europe, for instance, which are still valid, for instance, in the Austrian civil code, and even in the French civil code, you find in the civil code a series of fundamental rights or human rights, however you call them. They were needed in a codification because there were no constitutional surroundings for these texts. Today, I think everything shifted from private law to constitutional law, at least in those parts of the world where I live. You can observe the same, by the way, in tort law. You could say tort law serves the protection of human rights between citizens. And there is a lot to be said about the English tort law, which obviously has that origin. Trespass, for instance, is a kind of a constitutionally protected right, if I may use that word, but it appears in private law.
Thanks. Okay, so now another question, which I think might seem a bit more technical, but I think is really interesting, from Pascal Pinochet. How to adapt these reflections to a contract passed by a woman with a medical doctor to treat an embryo in utero? Can this embryo be a third-party beneficiary? And how do you implement the aspects of human dignity to the contract?
Yeah, the embryo is always a problem. My answer would be that a child in the mother's womb has no capacity whatsoever, at least no capacité de jouissance or Rechtsfähigkeit, as we call it. Everything depends on being born alive. before anybody is born alive, he is not a subject of private law rights. But once born, there is a retroactivity in these rules. Once born, you might be regarded as having lived already a few months earlier. That is the trick.
Right. Okay.
If, for instance, this baby in the woman's womb is lost by an accident, who has the damages claim? Certainly the mother, and certainly not the baby which never lived as a baby.
But you would accept that once born, the baby might have rights. Indeed, must have right, must at least have passive rights, I guess.
Once born, they have rights, and you can even say, and most of the codifications say that once born, they have acquired the rights, well, 3, 4, 5 months earlier. But it is always a prerequisite that they are born alive.
Okay, thank you. Okay, so now Matthias Stormer asks, is it not hubris to believe that our conception of civilized is the only one possible? Is that not another form of totalitarian thinking?
Well, my answer is a clear no. If we want to protect human dignity, that is the opposite of totalitarian thinking.
Okay, well, Matthias may want to come back, I don't know. But meanwhile, I'll ask a question from Paul Kane in Dublin. Are contracts for surrogacy consistent with human dignity in the sense that you've discussed? And if so, what principles should be applied to distinguish those which are lawful from those which are not?
There is an enormous amount of case law about surrogate motherhood. There is a huge political dispute among the various countries whether surrogate motherhood should be allowed or not. The German law, for instance, does everything to prevent surrogate motherhood. But as far as I can see, all the European countries recognize a surrogate motherhood under the law of foreign countries. The reason then is that when these cases come to court, there has already a considerable time passed between the birth and the decision. The baby will be with the new parents. And then it is in the best interest of the child to protect that new relationship. So there is a human rights question if the European states do not recognize surrogate motherhood contracts under foreign law. The last country or the last court to follow this route is, by the way, the Cour de Cassation in Paris.
Okay, well, we're now getting a little debate among the members because Pascal has queried the notion of human dignity having retroactive effect. Really? And Hector answers that retroactivity is okay where it is to the child's advantage, he thinks. At least in Scots law, the unborn child can, as it were, obtain property by inheritance and recover damages for antenatal injury. And I guess that would fit with your notion.
Yes, it does. Recover damages for antenatal injury. That again depends on whether the baby is born alive or not. If the baby is born alive, I see no difficulty in granting the baby damages for something that has happened before they had acquired personality.
Right. So presumably you then regard them as a passive recipient of rights. They obviously can't be active. And I was slightly puzzled by the distinction that you were drawing between active and passive. It seems to me that you were saying that all beings should somehow be given active rights, and that somehow passivity should be kept for the cases where it's absolutely necessary because somebody is completely incapable. Presumably it would follow from your analysis that someone else, viz. The state in the last resort, must protect those who have passive but not active rights. Is that right? Is that what you're arguing?
Yes, more or less. We have an enormous difficulty of language here, because all our continental systems, and I think Scottish law as well, distinguish between the capacité de jouissance and the capacité d'exercice, or Rechtsfähigkeit and Geschäftsfähigkeit. You find that in all our codifications. Now we have the difficulty to translate these codifications into your language. And all people, or all texts that I have seen in the English language, whether these are translations from Estonia or the Czech Republic or anywhere else, use passive and active legal capacity. I know that active and that passive and legal capacity are no terms of art in your country. But you have no better word for what we are doing here. So this brought me to use this passive and active capacity. It is in itself not a sharp distinction, of course not.
Okay, so now there's one to challenge your IT skills, Christian, from Raja. Do you think it's possible to express the notion of dignity in an algorithmic way so that an artificial intelligence system can recognize if its decisions are attempting to or are respecting human dignity?
What a question. I think the two would contradict each other. If I express the content of human dignity in a mathematical fashion, then the whole concept is lost.
Mm-hmm. Well, I think some people would say it all depends on the programmer, as it were. If the programmer can program it correctly, then maybe it can be done, but I have absolutely no idea.
Yeah, I wanted to avoid that answer because I do not know enough about programs.
Me neither. Okay, so Agnieszka Cyril asks, or says, a natural person has a partial legal capacity in private law from 13 years old in some countries. The scope of this partial capacity may be different in different countries. Should it be harmonized in all EU countries, especially in the scope of e-commerce? And I think that links with the question which has always worried me about the efforts we've made so far on European contract law, particularly consumer contract law. We've never dealt with the law of minors' contracts. And it seems to me that there must be enormous numbers of minors' contracts, some of which, of course, have nothing to do with human dignity, but others do.
Yes, the answer is simply yes. But I didn't want to start with this question of harmonization. I wanted to start with trying to understand what we are doing. But in the Lando principles and in the DCFR, we are lacking rules on capacity, and not only on minors, of adults, of course, as well. But you are right, minors in particular, because they are playing on their computers all day. And there is an enormous lot of questions.
Yeah. Okay, so a question now from Katarina Wolke. You've mentioned that another example for your thesis could be changes of sex or legal gender recognition. I'd be very interested in some more explanation of that point. You want to go any further? You feel able to go any further on that point?
Yeah, change of gender is of course not organized solely on a contractual basis. You always need state recognition for the change of a gender. But under the European Convention, Article 8 of the Human Rights Convention, one has a right to change one's gender. The open question is still how many genders the legal systems must accept. One question is change of gender from male into female and female into male. That in principle must be possible. That is a fundamental right. The other question is whether we need a third gender, at least a third one. The German and the Austrian Constitutional Court have said yes, for constitutional reasons, fundamental rights reasons. Germany, as far as I understand it, is the only country so far, but I might commit a mistake, that allows to register no gender at all. Neither male nor female nor a third gender for which there are various names, but not to register a gender at all. I have no idea whether in the long run even the three genders will be enough. If you look at social media, you can see that there are some platforms that are called, I think, which offer already today 66 different descriptions, or to put it short, 66 genders in inverted commas. My impression is, in the long run, we must get rid of gender as a notion of private law.
Okay, and then one very last comment I think we'll squeeze in. I think it's a comment as much as a question, though it's a very important one, from Ilaria Pratelli. And I think it's driving, again, at the harmonization question. How about the sharp contrast in European legislations on prostitution?
Yes, there is, of course, something in my written text on prostitution, because it is very close to this area here. Prostitution is a good example with which one can demonstrate that there is not once and for all a uniform concept of human dignity. This has changed a lot. It has changed in every country. the modern approach seems to be to help and assist the prostitutes and to criminalize the clients, which again does not really fit. Can I economically help if I criminalize the customers? But I did not want to go into much detail here.
Well, Christian, thank you very much for answering all those questions, and thank you to all those who've contributed. And I'd like to end just by thanking you again for a wonderful lecture, and I'm going to hand over to Christiana.
Well, thank you so much on behalf of the ELI to both of you. Thank you so much, Christian, and thank you so much, Hugh, for a wonderful evening. It was a really inspiring lecture and a worthy event to commemorate Ole Lando. As I said in the beginning, this is a tradition, and the tradition is that the speaker of each year's Ole Lando Memorial Lecture will nominate the speaker of next year's lecture. And so, Christian, we're really looking forward to hearing you disclose the name.
Thank you, Christiane. I must say I have not only the pleasure, but I'm proud to announce Professor Hector McQueen from Edinburgh University, Professor Hector McQueen from Edinburgh University, as the next lecturer of the Ole Lando Memorial Series. Professor McQueen holds a chair of private law at the University of Edinburgh and is director of the Edinburgh Centre for Private Law. He specializes in legal history, the law of obligations, and intellectual property law. Hector was the Scottish voice in the Lando Commission and one of the key members of the study group which drafted the DCFR. Hector's memoir of Ole will appear in the next issue of the American Journal of Comparative Law, and I confess I'm very much looking forward to reading that. We are now pleased to share some words from Professor Hector McQueen himself as he reminisces about his time with Ole Lando.
Thank you ever so much. And after we've heard from Hector McQueen, we wish you all a great evening and hope to see you over the coming days at the ELI Annual Conference.
When I became the Scottish representative in his contract group in 1995. He was a short, stocky figure with his wiry hair firmly cropped. He walked as a man in a hurry, but he always took a half-hour nap after lunch. His eyes shone and he dominated a group, including many other notable European academic lawyers. Not in the sense that he tried to get his own way on every point, but rather that if he felt the discussion was becoming too abstruse or that we were forgetting the point of our work, he would call us briskly to order or propose a conclusion which represented, if not a compromise, a way forward that all could agree or live with. No one was ever humiliated or made to feel unworthy of being present in this process. There was humour too, not just his own penchant for jokes, but his recognition of when others succeeded in saying something amusing, even if it was at his expense. He held the group together and he kept it moving forward. It was a masterclass in leadership. What I also came to realize over the years I knew him was his idealism, built from his own personal experience, especially in the war years. The deep knowledge, built from his reading and research over many decades, and the amazingly retentive memory, which allowed him to draw insightful pen sketches of the many eminent jurists whom he'd either met or heard about from those who had met them. At the same time, he could talk warmly and sympathetically about others in his life, such as his parents, or Miss Jessica Munro, his Scottish landlady in 1950s Oxford, who was a divorced, short-necked, small lady whose dyed reddish hair reached down to her waist. Her son was a college librarian. She and her son, wrote Ole, were not poor, but they needed a paying guest. The euphemism is a delicious echo of post-war Britain. We talked a lot about her in particular when the Lando group met in Edinburgh early in 1999, and we walked back together from a Rose Street pub with strong literary associations that interested him. He was also seriously interested in art and music. Being with him was one of the great experiences of my life.